Okay, today we are going to continue talking about intergovernmental organizations and this concept of the rise of the IGOs. And just as a preface, what I mean by that is this is the idea that since, well, primarily since World War II ended, but this was occurring after World War I and even prior to World War I. But the idea that, especially after World War II, we have seen really a large growth of organizations that have been formed by various countries around the world as IGOs, intergovernmental organizations, with the idea that international law historically had been really kind of a here and there type of thing, where countries would be left to their own devices to try to resolve potential conflicts. Treaties were really done in a reactive manner rather than a prospective manner. And international law as a whole was really kind of that way. And what I mean by that when I say reactive versus prospective, reactive means something has happened or is developing that's bad, and you react to what is happening. And sometimes in that sort of situation, you're not left with a lot of options, or it's up to the countries themselves that perhaps are in the dispute to try to resolve the problem after the problem has already occurred. And that's not always the best way to resolve problems. Generally it's not, because one, there's a lot of, well, emotion and everything else, political angst and everything else going on, and it can lead to problems, as opposed to prospective. Prospective means you're looking forward to try to resolve problems or create mechanisms to resolve disputes before they happen, or if they do happen, to try to resolve them through diplomacy and discussions and negotiations rather than threatening military or economic use of force. So when we talk about the rise of the IGOs, again, you have to look at the context of World War II, well, World War I and World War II together, where World War I really blew up and happened a lot because countries that were involved just simply could not discuss among themselves in a diplomatic manner how to resolve a dispute. And that brought all the countries into war. And of course, World War II, we saw the rise of Nazi Germany and everything else. And again, during World War II, and even prior to all the atrocities that occurred, the idea post-World War II was, instead of having, from an international law standpoint, this idea that countries need to figure things out on their own, let's move towards this idea of having permanent organizations that are designed to, number one, provide this concept of, let me go to the next page over here, to provide a permanent forum and these other issues. Let me see if I can get that to focus a little better. So first of all, this idea of a permanent forum, and what I mean by that when I say permanent forum, I mean an organization that has headquarters, or some place where everybody knows where it's at. You have diplomatic representatives from member countries that are stationed and available 24/7 to be available to discuss potential problems, to provide a place for the international community to discuss issues that are occurring that may lead to a conflict of some type. Also to discuss issues leading towards prospective development of international law. And this is kind of a hard subject to sort of understand at first, the difference between this idea of organizations versus countries having to try to resolve issues on their own. And it's sort of a basic kind of idea of dispute resolution methodology. We see the same thing in domestic law, especially in family law, where you have spouses that are fighting with each other. It's difficult for them to kind of see things objectively, to try to work things out among themselves, and it can lead to a heightening of the conflict, where if you can nip it in the bud, so to speak, provide mechanisms for a third-party mediator, a counselor, lawyers and arbitrators that try to work things out between the spouses that are in dispute. It cuts down on this whole idea of conflict being the way to resolve the dispute, as opposed to discussions and dispute mechanisms such as courts. And so this idea of a permanent forum is one of the fundamental basic concepts of the rise of the IGOs, to create this ongoing permanent place where discussions can be held, where issues can be brought to the attention of the international community in a manner that is not threatening, at least to a degree, versus, countries just basically screaming at each other. We see this idea of a permanent forum intertwined throughout IGOs throughout the world. We especially see it in the United Nations. We're going to look at the UN in next class in a little bit more detail, but that's one of the fundamental purposes of the United Nations, is to provide this idea of a permanent location. New York City, the UN headquarters, also in Geneva, Switzerland. They have facilities there and throughout the world, really. But the idea that if there's an issue that can be brought to a forum, it can be discussed either at the level of the General Assembly or the Permanent Security Council to try to resolve the thing before it blows up, or if it does blow up, so you have collective action by countries working together to try to resolve the dispute rather than just two countries fighting it out. I mean, that's kind of the idea I'm getting at. And, whether or not that's works or not, that's a matter of debate, but in the big scheme of things, that's the idea going forward, is rather than have international law left to countries that are basically disputing with each other, let's move towards this paradigm or this idea of having international law developed by a forum type of a concept. Almost not a legislative, perhaps, but at least more collective thought and discussion as this idea of rule of law versus rule of force. So we talk about the rise of the IGOs. This is one of the important concepts of the purpose of IGOs. Same thing with the World Trade Organization, which we'll look at more next week. The idea of the WTO for economic purposes is to provide a forum whereby the countries that are members of the WTO, again, have a place to meet. They're in Geneva, Switzerland as well, and they have a headquarters there, and there are about 160 countries that all have representatives at the World Trade Organization, and the idea is that they can discuss issues regarding international trade to try to reach a consensus on how international law governing international trade should be carried forward. And again, the idea there is to avoid, from an economic standpoint, this whole idea that has really gone on in the past where economic, especially tariffs and taxes and trade embargoes, where you prohibit importation of goods from certain countries, that was used very much as a political tool, both in the US and throughout the world for that matter. And the idea of the WTO is to provide this permanent forum where, instead of relying on countries that may engage in high tariffs and embargoes and prohibition of trade in goods, instead they meet at a forum, they discuss issues, they all agree on the same rules, and if there is a dispute, they have built in a dispute resolution process rather than countries basically warring against themselves. So that's kind of this whole idea. Dispute resolution systems is another fundamental idea when we talk about rise of the IGOs. And again, that's putting into place mechanisms like we see domestically, court systems and other ways to resolve disputes without essentially military or economic force. That includes the International Court of Justice and the World Trade Organization. They have a whole very detailed dispute resolution mechanism where if countries feel other countries are not following the rules, so to speak, they can take the dispute to the WTO. You have 160 member countries that then are engaged in that dispute resolution process. And it's a very well-designed mechanism that has very specific rules and timelines, so it provides structure to resolve disputes, as opposed to just leaving it up to the countries themselves. Historically, if there was a trade dispute, oftentimes a country would just flat out say, okay, fine, we're not going to trade with you anymore. We want to allow your goods into our country. We want to allow your people to come in and work. We're going to put a heavy tax on your products, or just a flat out ban on your products. And then the country would retaliate by doing the same thing. Other countries that were affiliated would do the same thing, and it would essentially end up in a trade war. Post-World War II, again, forum and dispute resolution mechanisms, but also this idea of rebuilding after World War II is another contributing factor to this rise of the IGOs. And especially within Europe, this is part of how the European Union came into being, was the idea that we need to, within Europe, and elsewhere around the world, but the EU's focused on Europe, of course, the idea that we don't need individual countries within the European Union putting up roadblocks, essentially, to the movement of steel and coal for power, electricity, telecommunications, essential infrastructure type things that were necessary to rebuild post-World War II Europe. And so that's where we saw the rise of the European Union, sort of the foundations there, was in this common group of countries that agreed, okay, we're not going to put up barriers to movement of steel from one country to the next, so that, when I say barriers, I'm talking about taxes, tariffs, importation expenses, quotas, limitation on the amount of goods that can be transferred. The idea was, let's bring down those barriers to trade so that we can help rebuild Europe. And that led to eventually to the European Union, which is probably right up there with the UN in terms of authority on a IGO type basis. So provide a permanent forum, also provide dispute resolution mechanisms in terms of court systems, also within the European or the international community, international arbitration and other dispute mechanisms so that disputes can be resolved in a legal setting rather than a military or economic force type setting. Here's this term I use over and over again. We're going to see it. It's written right into the United Nations Charter. Progressive development of international law. Once again, the idea being, let's have a forum. As part of that, we have the ability to look forward and to create treaties and conventions to hopefully put ground rules into place so everybody's playing by the same rules, so that treaties and other international law is published. It can be researched. It's not done secretly under the table. No side deals and that kind of thing. So that's this whole concept of progressive development. Harmonization and codification. We've talked about that a little bit. I'll get into that more in a minute. But essentially that's the idea that one of the functions of international organizations is to provide this tool whereby countries can harmonize their laws, put into writing in treaties and conventions, international custom and other rules, which again leads to, if you have countries that have different laws but they agree to make their laws more or less the same, that will reduce disputes and potential problems because everybody's playing by the same rules. And then eventually potential legislative-like power, which we'll talk more about later when we get into supranational IGOs. And then the idea that use of force on an international basis ideally should be based upon collective, collaborative effort rather than one country essentially using their military against another country, and also to reinforce the idea that countries have the right to self-defense, but other types of force should be based upon consensus and agreement of the international community rather than just fighting it out. Now these are all, of course, academic in a way, these goals. We all know in the real world they're not always followed or effective or enforced, but setting that foundation with this idea of having organizations take over some of these functions that historically were left to the individual countries in a conflict, that's the idea going forward. Okay, so when we talk about IGOs, provide a permanent forum, ongoing permanent forum to discuss disputes, bring issues to the attention of the world community, suggest resolution possibilities, if not mandate them, promote formation of international law, and then here, avoid ad hoc international lawmaking and dispute resolution. So let me talk about that term ad hoc. We see it in lots of different areas, business and throughout, but what does that term mean? Ad hoc means sort of issue specific. Issue specific, for a specific purpose. Sometimes you'll see in the news, perhaps the legislature, Congress, or a state legislature, or even a school district will form an ad hoc committee to study a particular issue and then to make recommendations about how to resolve that issue. So that ad hoc committee, maybe the purpose of the committee is to investigate and raise funds to build a new school building of some type. So it's issue specific. When we talk about ad hoc international lawmaking and dispute resolution, this is kind of the term that refers to what I was just talking about. Ad hoc, leaving it up to the countries that are in the dispute to react to a problem that has already developed, and then to try to resolve it among themselves in an ad hoc way. So ad hoc means issue specific, but it also kind of means, when I talk about international law, sort of a reactive approach to international lawmaking, international dispute resolution. That is, trying to get the countries, other countries say, hey, that's not our problem. Leave it up to the countries that are in the dispute. Well, that always can, that can lead to more problems than it solves, as opposed to having a forum that can basically say, here's what we recommend you do to resolve the dispute, and if necessary, at least at the UN level, it may go to the level of the Security Council where they could even authorize collective military activity. So to avoid this ad hoc or reactive type dispute resolution, which may lead to military or economic or other type of conflict. And again, promote rule of law versus rule of force, and the idea of equality of nations. That is, even though you have a disparity in size, military or economic power on an international level, within an international court, within an international forum, countries have the same standing in terms of authority and that kind of thing. Now, for you guys, I'm going to have an essay question that basically talks about what is meant by the term of the rise of the IGOs, what are some of the terms we've used in class, and this is where I want you to fold into your essay, harmonization, codification, progressive development, ad hoc, what is the idea behind a forum. That's what I want you to write about. And I'll just give you a little aside right now on essay questions. Here's how I grade, and this is true for most professors. When I'm grading an essay, I look at kind of three things. Number one, I have a list that I make up on my own of the vocabulary terms that I think are relevant to the essay question. So I may have a list of 20 vocabulary terms that I think are relevant to a particular essay. And then, as I'm grading, I basically literally circle the term in your essay, and this is what I'm looking for. Number one, you use the vocabulary term that we talked about in class. Number two, I like to see it defined. So when we say forum, what do we mean by that? When we say codification, what's the definition? So use the term, define what the term means, and then explain how that term is relevant to the question. And that's kind of a formula for all essay questions. I took the bar exam, we had an 8 hours of essays. And that's what they're looking for when you take the bar exam. And that's pretty much true for all essays. So use a vocabulary term, define what it means, and then explain how it's relevant, pros and cons, to the question that's being asked. So If I have 20 vocabulary terms on it, I'm looking for maybe somebody to use 5 to 8 or 10 of them. I'm not looking for all 20. Some of them are more relevant than others. But that's kind of a formula you can use when you're answering an essay question. Answer the question in using vocabulary terms, define what they are, and then explain how they're relevant. Okay, let's move on. Okay, on dispute resolution systems is one of the purposes or ideas behind the rise of the IGOs. So to provide structured international disputes resolution systems to resolve disputes by law rather than force. Now when I talk about that, what I mean is kind of two things. And this sounds so simple, and really in some ways it is. But first of all, setting up the system itself, that is creating the International Court of Justice, creating the World Trade Organization dispute resolution panels, which is a group of 3 people that will act as arbitrators and decide a dispute. So putting in place the system and putting into writing what are the rules on procedure. How do you file a claim if you have a dispute? So maybe Costa Rica has a dispute against the United States about taxes that the U.S. is putting on Costa Rican products. And Costa Rica feels that's unfair. Well, historically, you basically talked to the ambassador or tried to work it out. There was no clearly defined path to get that dispute resolved. Well, that's one of the ideas when I say dispute resolution systems, is putting into place very structured methods to resolve disputes, talking about what procedures there are. In other words, how do you file the dispute? How do you notify the other country that you have a dispute? What are the timelines? How long does the country that has been accused of doing something wrong, how long do they have to respond? What kind of response do they have to make? What if they don't respond? And then, what are the rules of evidence? What kind of evidence can be gathered? What sort of cooperation do the countries have to have in providing documents and other information to the other side? Who is allowed to represent them? Are we talking about lawyers? Are we talking about ambassadors or diplomats? Is it going to be done informally at first through just discussions? Some of those discussions may be moderated, facilitated. So, we have 2 separate rooms and we have a mediator going back and forth that will facilitate the discussion. We have rules on how that occurs. We have rules about, if there's costs involved, how those costs are shared. We have rules on a hearing itself. What are the procedures and methods that can be done? Again, timelines to all this. What happens if you lose? Do you have the right to an appeal? Do you have another right to an appeal? So it sounds so basic, but the reality is in international law, again, you have sovereigns. And they have to agree to this to be part of an organization. As part of that, they're agreeing to those process and procedural rules that really never existed before. And so that in and of itself, just the countries know, here's what I have to do if I want to lodge a complaint against another country, instead of just fighting it out. So, that's a very important kind of under the radar kind of thing when we talk about this idea of organizations providing dispute mechanisms. And we see that in the United Nations, we see it in the WTO, which is a very well-defined procedure, and we see it in the European Union. They actually have European Union courts, similar to our federal courts in a way. And we see that in what was formerly NAFTA, now the Canadian, American, Mexico Trade Agreement. But we see it in lots of different IGOs that they provide built-in dispute resolution mechanisms. So here we have, I've talked about that, international arbitration, which is very common and becoming much more popular. Arbitration is where you have a neutral third party that acts like a judge. Instead of having a court, you have an arbitrator resolve the dispute. And this is a very common method now for international dispute resolution, both between governments, but also private individuals. And again, it's providing those rules. The United Nations has developed a treaty, a convention on international arbitration that can provide these structural rules that the parties can adopt. That way they know what the procedures are going to be ahead of time, what the time frames are, and all of that. And again, it seems so basic, but it's an important part of this whole idea of Rise of the Igos. And then we have this last one here. There's another term I want you to be aware of. To provide individuals with standing to initiate dispute resolution by direct action versus a state. Let me explain what I mean by that. First of all, the term standing. This is a term that's used in law, both domestically in the United States we see this, and then also internationally. Standing, essentially, in plain language, means that a person has the legal right to bring the claim in a court. They are the ones that are personally either the one that was injured or has the legal right on behalf of an injured party to bring a case, to bring a claim to a court. And this goes back to the idea that there's a phrase that's called real party and interest. This is the idea that, and I'm just going to use a domestic court for right now, but it's true internationally as well. This is the idea that in order to, let's say, file a lawsuit, you have to be the one that's actually injured. You have to show that you're the one that is the party that is actually affected by the situation. So in other words, if you're, let's say, injured in a car accident, I have nothing to do with it, but I file a lawsuit on your behalf, which, not with your permission or anything. I don't have standing because I'm not the one that actually was hurt. Does that make sense? So you see this all the time. Courts will throw out cases. You see it in the news all the time. Courts will throw out a case because the court will decide the person that brought the lawsuit is not the one that has standing. They don't have the proper authority to have filed that case to begin with. And so the idea of standing is the idea that the participants in a case must be directly and actually affected in order to have the authority to file a case. Now you may be able to assign your rights to file a case. It's like, for example, if I am in a car accident and I'm injured and I get payment from insurance, insurance may take over my claim because they have now paid on my behalf, so they now have standing. But somebody that has nothing to do with it doesn't have that right. And I'll give you another example. I remember a case here a few years back. This has nothing to do with international law, but it kind of highlights this issue of standing. And there was a parent that filed a claim on behalf of their child that had been injured. Problem was that parent that filed the claim was not the custodial parent. Their rights as a parent had actually been taken away by the court. And the court threw the case out, saying there's a legitimate claim here, but you are not the custodial parent. You don't have standing. The other parent who had custody was the one that actually had standing. So standing is this idea that you have the legal authority to file a claim. Now on an international level, historically, standing only existed with a sovereign state. And that's still partially true today. There are many different international forums where only a state has the authority to file a dispute. So in other words, if I'm an individual person or a company and I'm harmed by the action of another government, I didn't have the ability to, let's say, file a case in the International Court of Justice. Or I didn't have the ability to file, and I still don't, in the World Trade Organization. And the reason why is, in both of those forums, only a state can bring a claim, not an individual person. And that historically has been true in international law. Well, again, with the rise of the IGOs, this is one of the goals of some of the international organizations that we see around the world, and that's to provide individuals, private companies, non-governmental organizations, NGOs, and other types of non-sovereigns with the ability to directly file a claim in an international tribunal if they have been harmed. Later on, we'll talk about the International Center for Investment Disputes, which is part of the World Bank. And they actually allow this. If you've been harmed by a country that is part of the World Bank community, you can bring an arbitration directly against a foreign government. And so we're seeing that trend as well. Again, this is state versus government when we talk about relationships in international law. And that's been another outflow of this idea of Rise of the IGOs, to allow individuals, private companies, and other non-sovereigns the ability, at least to a degree, to bring a dispute themselves without having to have their government do that on their behalf. So those are all sort of foundational issues. All right, so here's a term I've used over and over, and again, this is one that you should probably refer to in your essay, the idea of progressive development of international law. This is the idea that an organization provides the method or forum to promote forward-looking, proactive, looking forward creation of international law rather than being reactive. Looking forward into the future to try to resolve disputes, to try to put into place treaties, conventions, international standards like engineering standards, international trade and shipping standards, and other type of agreed upon rules ahead of time to hopefully cut down on disputes before they occur. And anticipate changes to technology, society, etc. Progressive development of international law is one of the primary goals of the United Nations, some of their adjunct components. The United Nations International Law Commission, which is a subunit of the United Nations, their job is specifically, as part of their creation, to initiate studies and make recommendations for the purpose of encouraging progressive development of international law. UNCTRAL, United Nations Commission on International Trade Law, another subunit of the United Nations. Again, the idea, their job is to put together progressive development for international economic treaties and conventions. United Nations General Assembly and the Economic and Social Council, ECOSOC. Again, their idea, and we'll look at this more on Thursday, we look at the charter, to make recommendations about progressive development for economic and social issues, human rights, international health, and other type of issues. Now, these are just some examples. So here's kind of what I'm looking for in terms of an essay question, or what I mean by this. How does the rise of the IGOs affect or create international law? And this is one of the ways that we see the ability of the UN, in this example, to be able to create international law. The UN cannot legislate, there's really only one IGO that kind of has legislative authority, and that's the European Union. When I talk about legislation, I mean mandating law. International law, by its very nature, is based upon consent of the sovereign countries. And so the idea of legislating on an international level really is sort of in direct conflict with the idea of a sovereign state. So how is international law created? Well, one of the ways is through IGOs, and that is the ability of an IGO to initiate treaties, to initiate studies, to initiate conventions, to put together ground rules for dispute resolution, for contract making, international trade. And that actually has the effect of creating international law, not by legislating, but through consent of the countries that are part of those treaties. And so this is a way that international law can be created by the UN and other IGOs, even though they can't legislate. So they can't mandate it. This is still voluntary, if you will. But it's a way that they can initiate international lawmaking, as opposed to leaving it up to the countries themselves. All right. Next terms I want you to be aware of, down below on page 70 here. Harmonization and codification. Okay, so when I use the term harmonization, which I will use frequently, especially when we look at the WTO and the European Union, this phrase refers to the idea of requiring member states of an IGO to have the same laws. In a nutshell, that's what it basically means. And when I say have the same laws, I mean domestically. So the countries, you may have, like the WTO, you have 160 countries. Each country has their own law. And those laws may be very different from one country to the next. And that can lead to disputes on an international level. Well, the idea of harmonization is the idea that an organization, the members agree that when they become part of the organization, they will take steps domestically to have their laws meet standards that are set by the organization. And if their laws don't meet those standards, then they will change their law to meet the standard. This is kind of similar to the United States. We're a federal government, so the federal government through Congress makes law that applies to all the states. Minimum wage, for example, perfect example. So the idea now is the federal government will set a minimum wage standard. States cannot go below that minimum. They're welcome to go above it, but they can't go below it. So same thing on an international level. The states will agree to harmonize their individual domestic law. We see this mostly in trade law, international business, import-export law, engineering standards, shipping standards like the size of a container that goes on a ship. Those are standardized. International shipping, categorization for how you impose taxes, how you describe products, so that all the countries have agreed we're going to use these same standards. That way all countries are using the same rules. And that's one of the goals of some of the IGOs around the world, is to provide that harmonization of international law. And that's done either direct action through treaties and conventions, or by setting standards which the countries then need to modify their law if necessary to meet those international standards. So that's what we mean when we talk about harmonization of law. Codification, again, this is another fundamental function of the United Nations, but also other IGOs. Codification is the process of putting into writing, through treaties or conventions, customary law or other international law, general principles of international law, jus cogens, etc., putting it into written form so that it is, in written form so that it can be adopted by other countries, they can join on, and that sort of thing. So, historically, a lot of international law was left up to customary international rules, which may not be in a written format, especially historically when not many people could read. And so those rules may change all the time. Nobody really has the ability to research them because they're not in writing. And so that's one of the ideas of codification, is to get away from non-written agreements and put those into writing so they can be researched and the rules are known. It's one of the functions of the United Nations, is to actually act as an international library for treaties and publish those treaties. World Trade Organization also requires that countries, as part of being a member of the World Trade Organization, must provide their written rules. They have to be transparent and available to be reviewed. It can't just be done secretly. And so that's this idea of harmonization and codification as one of the primary goals of an IGO. Again, with the idea, hopefully, to resolve disputes before they occur and cut down on disputes because everybody knows what the rules are and have the ability to raise a dispute in a forum rather than through military or economic action. Okay, next page over. So, this is what I was just talking about. This is one of the controversial areas of IGO law. You know, the WTO is fairly controversial. You guys ever hear of the battle in Seattle? No? So the WTO, this is, I can't remember, I think this was in the 90s, was meeting in Seattle, Washington, and there was just all kinds of riots and protests and stuff going on, you know, demonstrating against the World Trade Organization. And depends who you ask, of course, like anything, but one of the fundamental arguments against the World Trade Organization is that it is a form of an international world legislature in a way, and that it takes away individual human sovereignty and country sovereignty, and it's done at a state level without direct involvement of representatives that are elected, and there, you know, there's a lot of issues surrounding the WTO, and that's one of them. And so one of the arguments against the WTO, but this is also true of other organizations internationally, is that it's taking away from sovereignty, it's taking away the ability of states to essentially legislate by engaging in international treaties that require this harmonization. And if you know, on a global level versus individual action at local level in terms of lawmaking. At the end of the day, under our Constitution, as well as other countries, international law can override lower level law, including law made at a state, city, or county level, or even at the federal level. And so this is one of the arguments against international organizations, is it's taking away local control, you know, local meaning either city, state, county, whatever you want to, however you want to define it. So that's one of the arguments against it. So this idea of legislative-like power is, from a theoretical concept, how far or how much power do we give to an IGO to the point where a country no longer is a sovereign state because they have transferred so much of their sovereign power to the IGO itself. And you know, at what point does the state no longer exist? Because now the IGO essentially can control the domestic law of a state through treaty making. That's more of a theoretical concept, but you know, as time goes by into the future, we'll probably see more and more of this. So this is one of the balancing issues you got to look at from a theory standpoint of international law. How much power do you give to an IGO before you lose sovereignty of a state? So that brings up this term that I want you to know right here. Supranational power. Supranational power. So we talk about an intergovernmental organization. Supranational power means that the IGO has essentially power over the member states that make up the IGO. And then the IGO itself essentially has the ability to write international law that is superior and will preempt, that is, override, domestic law of that state. Now, most IGOs do not get to this level because essentially the sovereign states are giving up a lot of their authority as a sovereign. Really, the only example that we have of what I would call a supranational IGO at this point in history is really the European Union, where the member states have transferred a lot of their individual lawmaking ability to the EU as an IGO. Now, that's done through agreement of the states. They still retain their sovereignty, but they have agreed to this. And then, of course, in the EU, the citizens can vote on it as well, as part of how the EU is structured. And we'll look at the EU a little while later. So this idea, when I say supranational power, that is basically an IGO that has, through the consent of the member states, the power to essentially mandate or require that other states follow the rules that the IGO creates. And the EU is probably really the only example we have right now. The UN does not rise to this level. Whether it ever will is not known, but that's what I mean when I say supra. Supra means above or outside, above or outside, versus infra, which means inside or below. So a supranational IGO is an IGO that essentially has the power to legislate, at least to a degree. All right, and the final topic here is the idea of international use of force. So this is the idea, again, post-World War II primarily. This is one of the fundamental purposes of the United Nations when it was created, was to counteract German power, well, not just Germany, but Italy and Japan and the other Axis countries at the time. And this was the idea that to cut down on potential war, or what could lead to war, that on an international level, if there's going to be force, it should be either in self-defense, or if it's going to be in an offensive manner, not defensive, but offensive, then that offensive military action needs to be sanctioned and agreed to by an international organization on a collective level. And this may include the idea that the organization on an international level may use force in certain circumstances to enforce jus cogens, that is a peremptory norm. And again, this came primarily out of World War II, where we saw the genocide and everything else, the idea that that is an international law issue, even if it's potentially only within the boundaries of a country. So this is one of the other ideas of getting away from rule of force versus rule of law through organizations, the collectively agreed upon use of force. We'll look at the UN Charter on Thursday. Within the Charter itself, you'll see this embodied in how force can be authorized by the Security Council or other action other than military, such as economic trade embargoes and that kind of thing. Now, does that happen in the real world all the time? We all know, no, it doesn't. But that's the theory behind it. So, okay, next page over. Let's look at some other specific terms I want you to be aware of when we talk about IGOs. So, first of all, we have the term customs union. So a customs union is a group of states that have agreed to establish a common external tariff or other rules of import and export that are the same among those countries. So let me give you an example of what I'm talking about. Okay, so let's say we have countries A, B, C, and D. So when we talk about a tariff is a tax that is placed upon goods and services, primarily goods, when they are imported into a country. So let's say I'm in country C and I want to import pens, ballpoint pens, from my country into country A. When I cross the border, I'm importing the goods from my country to their country. I have to cross that border. And when I cross that border, we have what we call barriers to import, or trade barriers. And these are any kind of a barrier, or basically a hoop that I got to jump through to move my goods from one country to the next. Now, there are lots of different kinds of trade barriers. We'll get into those more when we talk about the WTO. But one of the trade barriers is a tax. So country A may impose a $1 per pin tax on any pins that are imported into that country. So for every pin I move from one country to the next, I got to pay $1 of tax. That's a tariff. So the idea of a tariff can be used, one, to generate revenue, but it can also be used in a political way. So for example, country A may not like country E, but they like country B and D, and they're neutral in country C, whatever. So country A may impose a $2 tax per pin on country E, but only a 20-cent tax on countries B and D. So you have different tax rates depending on the origin of the product. Now, this historically has been used as a form of political force in a way, or economic force, to force countries to do things. Now, country E, as you can see, is much bigger. So country E may have a bigger military and economic power than these other countries. And so if they don't like country A, they may say, we're going to impose a 200% tax on all of your goods, or just a flat-out embargo, meaning if you're going to put $1 tax on us, we're going to not allow any of your goods into our country. And then they do vice versa. That leads to what we call a trade war, using import and export for a political purpose. So one of the ideas of a customs union is a group of countries that will agree to apply the same tax to products coming into any one of their countries. And that way, they don't engage in fighting amongst themselves. Also, they can have the ability to have higher taxes than if they were imposing different tax rates and essentially competing with each other. So for example, if country A says we're going to impose $1 per ballpoint pen, and country B says, well, we're only going to charge 50 cents, then more of the trade is going to go through country B than country A. And then country A may say, well, fine, then we're going to only charge 25 cents. And eventually, it becomes a race to the bottom. And so they're all losing out on revenue. Or vice versa. They all want to reduce the amount of taxes or other type of barriers, inspections, engineering standards, etc. So we talk about a customs union, we're talking about countries that have agreed to apply the same rules, harmonization, within their group of countries to all products coming into those group of countries, the same. Now the United States, in a way, is a customs union. All of our import and export laws are federal. That means that the same rules are applied if I'm bringing goods from France into Idaho or Florida or Oregon. The same rules will apply. That's created by federal law. On an international level, that would be done through a customs union, which is a form of an IGO. And we see lots of these around the world, very, very common. The whole European Union is a giant form of a customs union, as are other areas around the world that have economic units. Now, very similar to a customs union is what we call a free trade area, an FTA, free trade area. This refers to groups of states that have established or eliminated trade barriers between themselves, but maintain individual trade barriers for states that are not part of the agreement. So a free trade area type of a customs, or a free trade area type of an IGO would be, let's say, country A, B, and D agree that they will take down their borders for movement of goods and services, perhaps, within those countries. So if I'm from country D, I can move goods through country B over to country A without paying a tax at the border or other type of trade barriers. So they've agreed to reduce or eliminate, or perhaps they still have a tax, but it's only 1 penny per pin, and they all agree on $1 per pin for any goods coming in. So a free trade area is a form of an IGO where the countries that are part of that agreement, the free trade agreement, have agreed to either eliminate completely or greatly reduce any barriers to trade between the countries that are part of that agreement. Again, the United States sort of is like this. If I want to move goods from Oregon to Idaho, for the most part I can just cross the border. I don't have to pay a tax when I go into Idaho with the goods from Oregon. European Union, probably the best example of this. Within the European Union, it's a giant free trade area for the most part, where you can move goods within the member nations without paying tax when you go from one country to the next. So that's what we mean when we talk about a free trade area. So customs union is looking outside. That is, goods coming in to the countries are treated the same. A free trade area is looking inside. Movement of goods within those countries. Now you can be both. European Union is both, a free trade area and a customs union. They have established the same rules for goods being imported into any of the member countries. They've harmonized their laws, and they've reduced down internally any tariffs or taxes or other barriers to trade internally as a free trade area. So you can be both. All right, the next type of IGO, when we talk about trade law or international import-export, is, this goes by different terms, Economic Consultative Association or Economic Trade Association, or any similar number of terms. And these are basically countries that, for purposes primarily of a specific product or type of product, have agreed to establish the same rules in terms of production, how much they will produce and allow to be exported. Probably the best example of this is OPEC, oil producing states. And again, they will establish the amount of production that the states will meet, either raise production, raise supply, or diminish supply. And of course that will have vast impact on the price of oil. Now this may be sugar, this may be iron, this may be lithium, big time now with batteries. So we're talking about specific type of products or groups of products where countries basically have agreed to collude to form the same rules on production or other type of trade to either benefit or to raise or reduce supply. Or this may be an offshoot of a free trade area that combines both free trade and then also collective price movement. Oftentimes that forms a sort of monopoly in a way, if you look at it that way. We also see that in food products, bananas, sugar, other type of areas. So these are various different type of IGOs that I want you to be aware of, and I'll use those terms. Especially we talk about the WTO and the European Union. These are forms of these free trade areas and customs union type IGOs. Okay, it's real quick on NGOs. I'm not going to spend a lot of time on NGOs, but when I use the term NGO, I'm referring to what's known as a non-governmental organization, and that is primarily in international law, some sort of a multinational organization that has international activity. It may be for-profit, or most of the time an NGO is a non-profit, which may include like the Red Cross, parts of the United Nations, various different adjunct facilities of the United Nations, and they engage in international activity. The reason why the status of being an NGO is important, I can't remember if I have a slide on that or not. Yeah, here we go, next page over. So this is the definition that's provided for an NGO under World Bank rules. So an NGO is a private organization that pursue activities to promote basically social well-being, the environment, community development, other types of things. So within the World Bank, the reason why that's important is if you are an NGO and you want to obtain World Bank money either through a grant or a loan type program, you have to meet their definition of what is an NGO. Now NGOs in a broader sense are non-governmental organizations that have international activities such as the Red Cross or whatever, which may not fall within the World Bank definition, but they're still considered an NGO. And then I'll give you some examples there at the end. All right, then finally, when we talk about persons in international law, we have individuals and private companies. And really, what I want you to know about that is historically, there's that word standing again. Historically, under international law, the individual person had no standing. They had to, if they had a grievance against another sovereign, they had to take their grievance to their own country, their own sovereign, and try to get their sovereign to take on their dispute, which they may or may not be willing to do for political, military, economic reasons. Again, one of the goals of IGOs has been to, and NGOs for that matter, has been to establish and put mechanisms in place whereby individuals have standing under international law. That includes the recognition of human rights on an international level, like the United Nations Essential Declaration of Human Rights, and the idea that individuals do have rights under international law, where historically they did not. And this again primarily arises out of the idea of a peremptory norm, jus cogens, coming out of World War II. A fundamental shift, meaning that international law is not just the realm of sovereigns now. We also have individuals that have rights, to a far limited degree, of course, in a state, but still there are cases where an individual will have the right of direct action, where historically they never did. And we'll probably see that continue to develop as time marches on. More of a individual rights within various different IGOs. Okay, so